if their duty, their honor, and their oaths will not bind them, let us not put into their hands our liberty and all our other great interests. Gouverneur Morris, the penman of the Constitution, the author of the preamble to the Constitution, he did not mince words. But despite that warning, despite that advice, politicians today across the political spectrum, they violate their oath to the Constitution almost constantly, 24/7, 365, and they never seem to pay the price. The people, I think it's out of ignorance or fear, or maybe a lack of self-respect. Their standards are just way too low in what they deserve. Maybe a combination of all of this. They don't hold them to this standard. And on this episode, I've got a bunch of insight, warnings, and advice, and a bunch more great quotes on the oath to the Constitution from the founding generation that we can't afford to ignore any longer. But first of all, before getting to that, welcome and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Monday, November 4th, 2024. Let's start out with some text from the Constitution. Here, Article 2, Section 1, Clause 8.1, Oath of Office for the Presidency. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. And for everyone else pretty much in office, there's this, which is in Article 6. They don't spell out the exact text of that oath, and that has gone through legislative changes over the years. But here's how it is in the Constitution. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But there's a caveat. No religious test, and I'll discuss this briefly a little bit later in the show, no religious test shall ever be required as a qualification to any office or public trust under the United States. And so, as I mentioned, they have changed the text of that oath over time. Here, for example, from the United States Senate, they put it this way. I do solemnly swear or affirm, and we'll discuss affirming here in a little bit as well, that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. Enemies of the Constitution. What is that all about? That I will bear true faith and allegiance to the same. That I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter, so help me God. So this oath of office, and there was some debate over it. Some people didn't like it. Some people didn't like the context or the text of it. But it was so important to the vast majority of the founding generation that it was the very first act passed by Congress, and it was the first law signed by the first president, George Washington. That was an act to regulate the time and manner of administering certain oaths. It was signed into law June 1st, 1789, and it prescribed, and this is from the National Archives blogs, it prescribed the text of and procedure for the administration of the oath of office. They write that the act mandated that the oath be administered in the following form. And this is the original version. I do solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States. And it was a simple, straightforward oath they point out, that fulfilled that constitutional requirement in Article 6. This is the first law passed by Congress. Now, in essence, the founding generation understood the oath as basically an appeal to heaven. Here, for example, is Oliver Wolcott, very influential guy in the Connecticut Ratifying Convention. This is in January of 1788. And he said the Constitution enjoins an oath upon all the officers of the United States. This is a direct appeal to that God who is the avenger of perjury. Such an appeal to him, he said, is a full acknowledgement of his being and providence. An acknowledgement of these great truths is all that the gentlemen contend for. And James Iredell, who was one of the top legal minds of the time in the North Carolina ratifying convention, top legal scholar, he was nominated to be one of the first associate justices on the Supreme Court by President Washington. And he describes it. He says, according to the modern definition of an oath, it is considered, quote, a solemn appeal to the supreme being for the truth of what is said by a person who believes in the existence of a supreme being and in a future state of rewards and punishments according to that from which will bind his conscience most. So this was basically an appeal to say, well, if you believe these things and you don't follow your oath, you are going to have some problem. It was some kind of an outside pressure. And here from Rob Natelson in an old paper that he wrote, a law review paper, The Original Meaning of the Establishment Clause. It's very interesting stuff if you want to get really deep into it. He points out that the view that oaths and theism were necessarily connected was more than just merely a view. It was considered the law. The essence, he said, of an oath was an appeal to God and to witness the truth, appeal to God to witness the truth of what one said. Thus, the oath of an atheist, according to the founders, received no recognition. Or, well, James Madison had some thought on this as well. The English courts ruled so prior to American independence, so this was part of the legal tradition, the system of precedence under the unwritten British Constitution. But American courts, he said, also acknowledged this principle as late as 1823. And if you want to get into that, this is a very long paper. You can get a little bit more detail on some of the things that were covered. And I think that brings me right back to Gouverneur Morris's great quote. This is in the Philadelphia Convention in July of 1787. Again, if their duty, their honor, and their oaths will not bind them, let us not put into their hands our liberty and all our other great interests. But he continued and he said two other things. He said, if these ties will bind them, we need not distrust the practicability of the rule. So people were debating like, oh, how do we approach this? What's the right way of doing it? And he's like, look, if you have people of duty and honor and they're taking an oath to follow something and you bind them, you have to be less concerned about some of the particulars. But if we can't find people that will be bound by their duty, their honor, and their oaths, he says, let us have no government at all. And I know that Gouverneur Morris was not trying to threaten us with a good time there, but the principle really, really hits home when you think a union of states that really acts more like a singular nation, the way it wasn't supposed to be. A union of states with over 300 million people. If you're struggling to find just a few hundred people, a tiny, tiny percentage of the entire population, if you can't find a few hundred people or one person, 5 people that will follow their oath all the time in every situation, the Constitution, every issue, every time, no exceptions and no excuses, what's the point of giving these people trust over your liberty and all these other great interests? You'd be better off without them in office at all. So, but seriously though, without threatening us with a good time, if these people don't have any honor, what's the point? And even an oath of fealty to the British king, to the founding generation, it was seen as a reciprocal oath. It wasn't a one-way street. You just yell something out there and that was it. No, in a 1775 sermon, Moses Mather described it like this. He said, there is also what is called a legal allegiance, ex provisione legis. That is and I always get the Latin stuff wrong, so my apologies on that. That is by positive institution as the oath of allegiance taken by the subjects, wherein they swear to bear all true and faithful allegiance to the king. So total fealty to the king, obedience. And we don't think of it as a two-way street, really, but this is how Moses described it, which is a counterpart to the king's coronation oath, whereby he swears to protect his subjects in all their just rights, to abjure popery and maintain the Protestant religion, to govern the kingdom and administer justice according to the laws of the realm. So they're taking an oath today to administer their office according to the laws of the Constitution and nothing nothing else. Now, as a quick aside, a lot of people have asked me over the years, why oath or affirmation? Why isn't it just oath? And Wikipedia, I thought this was fascinating. As usual, they get part of it right, and part of it just, they don't know what they're talking about. And here's how they put it. The constitutional language gives the option to affirm instead of swear. While the reasons for this are not documented, which is absurd, it may relate to certain Christians, including Quakers, who apply this scripture literally. Quote, "But above all things, my brethren, swear not, neither by heaven, neither by the earth, neither by any other oath. But let your yea be yea, and your nay, nay, lest ye fall into condemnation." So there were some people, primarily Quakers, but Mennonists, I believe, is the other sect that also would not swear an oath, but they could affirm that they agreed with certain things. Now, Wikipedia says, it might relate to Quakers, but we know that this was a discussion about Quakers all along. Here, for example, just a few months after the shot heard around the world in 1775, Lexington and Concord, this is now into August, George Mason wrote an ordinance for establishing a general test oath. And he said, "It has now become indispensably necessary by an appeal to heaven," because the British were pushing an oath and making deals. Hey, we'll protect you if you join up with us and you swear fealty to us and reaffirm that. And a lot of people were joining the British military at that point. And here's George Mason. "It is indispensably necessary by an appeal to heaven to enter into a more firm union for our common defense and to distinguish those deserving our protection from such as are enemies to our just cause." And he continued, this is the end part of the oath. It's pretty long, but this part I thought was interesting. "I do declare that I will defend and support this colony against all invasions and insurrections whatsoever that shall or may be made against the rights and liberties of America according to my abilities and pursuant to ordinances of General Convention. So help me God." Now, a lot of people think that phrase at the end came much later, but we see George Mason using this in Virginia in 1775 in the height of the American Revolution and the early part of the War for Independence, but added this, "Provided always that the people called Quakers shall affirm to the same effect and also subscribe the same." You can find references to an oath or affirmation in regards to Quakers all over the place during the American Revolution. You can also see oath or affirmation included in various state constitutions, revolutionary ones, and even Alexander Hamilton, his hated internal tax, the whiskey tax. It included this phrase about oath or affirmation regarding Quakers, I think in 5 different places. For example, "They shall attest by the same by oath, or being a known Quaker by affirmation." So the notion that we have no idea why they included that, maybe it had to do with Quakers, is absurd. I just wanted to point that out. Now, not everybody was on board with the oath under the Constitution, and it doesn't mean that they were opposed to the idea for oaths, although some people thought it was just absurd and it would be kind of a false security. But a vast majority of the people on the Anti-Federalist side, they just didn't like the wording in conjunction with what they saw as way too much power being delegated to the federal government or the new general government, or what they saw as a national consolidated government under the proposed Constitution. This, I believe, was John Smiley in the Pennsylvania Ratifying Convention, pointing out that Article 6, Clauses 2 and 3 are concluding clauses that the state governments will be abolished. So in other words, there will no longer be a union of states. It will be a singular national government. And as Patrick Henry warned, a singular government over such a great territory will absolutely destroy the liberties of the people. That's what he predicted. And here it says, the oath here required is contrary to the oath required by the Constitution of Pennsylvania. No member of the assembly will hereafter take the latter oath. So they're being asked to take 2 oaths, and maybe an oath in one of the state constitutions had something competing. So they were very concerned about that on the Anti-Federalist side. Here's Luther Martin, also in the Philadelphia Convention. He made this motion to strike out the words requiring such an oath from the state officers. He did not want to see the state officers taking an oath to support the Constitution for the United States. That was for the members of the government of that United States under the Constitution. So he moved to strike out those words from state officers within the several states, observing that if the new oath should be contrary to that already taken by them, it would be improper. So what if they already took an oath and now they're being forced to take another oath and maybe there's a conflict between the two oaths? You can't do that. And he said, if coincident, the oaths already taken, one will be sufficient. You only have to take one. Here's William Findley in the Pennsylvania Ratifying Convention pointing out that this is a consolidated government. I'm not getting into that debate here, but this was part of the discussion on the Anti-Federalist side. And he said it will abolish the state governments or reduce them to a shadow of power. And first of all, he points that from its organization, just like Patrick Henry mentioned at the beginning of the Virginia ratification debates in June of 1788, here in December of 1787, he says, we the people, not we the states. And one of his supporting arguments that says this becomes a singular national government under this system, or this is how it'll play out, he said the oath of allegiance shows it to be a consolidating government. So that was a proof of centralization rather than federalism. Here's Brutus, I believe this is Brutus in his second Anti-Federalist essay, saying it is therefore not only necessarily implied thereby, but positively expressed that the different state constitutions are repealed and entirely done away, so far as they are inconsistent with this, the proposed Constitution, with the laws which shall be made in pursuance thereof, or with treaties made or which shall be made under the authority of the United States. There was no such situation really anywhere close to it under the Articles of Confederation, and people like Brutus thought that was really, really bad. Another anti-federalist who did not really like the situation of the oath was Melancton Smith in the New York Ratifying Convention, July of 1788. He wanted the oath to be reciprocal, because if state officers had to swear an oath that they would defend the Constitution for the United States, even though they weren't part of the government that was formed under that, why wouldn't the federal people who are part of the federal government, the general government, why don't they have to actually take an oath to support the state constitutions? That was an example of how they were saying things were getting way out of balance. So he made a proposal that all the officers of the United States ought to be bound by oath or affirmation not to infringe the constitutional rights of the respective states. And I think in the Philadelphia Convention, it was Hugh Williamson that made a similar suggestion as well in the summer of 1787. Now, I should mention while I'm here that all these original source documents that I'm mentioning, plus some articles and essays and papers like that, they will all be linked to in the show notes. I am just plowing through this pretty quickly today. It's an interest. 'Tis the season, I guess, but it's a very interesting time, and I think this is really, really important stuff to consider when we're thinking about steps forward in the coming days, months, and years. But this will all be linked to in the show notes so you can read more in context on your own time rather than just taking these kind of highlight reel of the top quotes and insight. And Alan Mosley does a great job of organizing the blog post for every episode. He includes not just all the show links, but all the various platforms we're on. Of course, we live stream on the mainstream ones like Facebook and YouTube and X and LinkedIn and Twitch. We also live stream over at rumble.com and odyssey.com. We archive the video and the audio-only podcast edition all over the place. And if we're missing from one that you would like to see us on, please do let us know over at team@10thamendmentcenter.com or a comment in the archive. That will help out as well. So Alan will get that blog post organized and I will get it published over at 10thamendmentcenter.com/path to liberty a couple of hours after this live stream is done. Anyway, so we were discussing how some of the anti-federalists were not a big fan of the clauses with the oath to the Constitution, not necessarily against the idea of an oath, but because they didn't like the structure of the system. Now, some on the Federalist side also opposed the oath, but for different reasons. Like, for example, Roger Sherman, discussing Resolution 14. This is also on the 11th of, what's the date here? I should know. 11th of June, 1787. Resolution 14, requiring oaths from the members of the state governments to observe the national constitution, which is what they were discussing it, and laws being considered. Mr. Sherman opposed it as unnecessarily intruding into the state jurisdictions. He thought that was problematic. Now, James Wilson is the guy who most famously was opposing the oath, and he said he was never fond of oaths, considering them as a left-handed security only. You don't have to go after us left-handers, Mr. Wilson. But he said this is an interesting point. A good government did not need them. And a bad one could not or ought not to be supported. So if you think about it, it's very similar to what Gouverneur Morris had to say. Like, if it's structured with people who are good people, you don't need the oath because they're going to follow the rules anyways. And if you're having a bunch of people take an oath of office and you can't find the proper people to administer it, well, you can't support, could not or ought not be supported at all. And I think that's a very important perspective. Edmund Pendleton, in a letter to James Madison, just a few weeks after the end of the Philadelphia Convention, also suggested that oaths were basically useless. He said, my last criticism you will probably laugh at. And this is what this is a segue into discussing various parts of the Constitution. He said, though it is really a serious one with me. Why require an oath from public officers, yet interdict all religious tests, their only sanction? So he's saying, like, well, if you're swearing an oath and you can't prove that you're passing a religious test, how do we know you really believe it? He said, but since a belief of a future state of rewards and punishments can alone give conscientious obligation to observe an oath, it would seem that a test should be required or oaths abolished. James Madison, in response, he didn't necessarily agree or disagree overtly. He took a very interesting, he had a really interesting perspective on this, and he responded a few weeks later. He said, is not a religious test, as far as it is necessary or would operate, involved in the oath itself? If the person swearing believes, so this is kind of a contradiction in the Constitution. They're saying no religious test, but then they're requiring oaths. And if you don't believe in a higher power, for example, then, well, what are you swearing an oath to? What are you being held accountable to? And that's the argument that James Madison is saying. He said, if the person swearing believes in the supreme being who is invoked and in the penal consequences of offending him, either in this or a future world or both, he will be under the same restraint from perjury as if he had previously subscribed a test requiring this belief. So in essence, what Madison, the father of the Constitution, is saying, well, there is a religious test, in at least not necessarily overtly, but it's there. He said, on the other hand, if the person in question be an unbeliever in these points and would notwithstanding take the oath, a previous test could have no effect. He would subscribe it as he would take the oath without any principle that could be affected by either. So he's basically saying, like, if you find someone and they don't support one or the other, they're just going to say what they're going to say. That was James Madison's take. Now, the vast majority of the founding generation were certainly on board with the principle behind the oath to the Constitution. And Edmund Randolph, in the Virginia Ratifying Convention, he was the first Attorney General, George Washington's administration. He described it like this: the senators and representatives, members of the state legislatures, and executive and judicial officers are bound by oath or affirmation to support this Constitution. But the important part is, he said, this only binds them to support it in the exercise of the powers constitutionally given it. You can see a similarity to the arguments over the Supremacy Clause. People today tell us, well, all federal law is always supreme, but they always leave out the caveat that it requires federal acts to be in pursuance of the delegated powers of the Constitution. Otherwise, they're not supreme at all. It's the other way around. And it's a very similar approach that Edmund Randolph is taking here regarding what people swear an oath to support. He said, although officers, etc., are to swear that they will support this Constitution, yet they are not bound to support one mode of worship or to adhere to one particular sect. It puts all sects on the same footing. So that's how he's really describing the religious test versus the oath or affirmation kind of controversy or inconsistency here. He's saying, look, we're basically saying that we're going to be okay with any religious sect, and there is not any particular one that's required. That's how he was seeing a religious test. You can't require someone, as they had to do in Great Britain, what they fought a long bloody war. Part of what they fought a long bloody war to escape from was that type of a religious test. Now, Archibald MacLean in the North Carolina ratifying convention put it like this: can any government exist without fidelity in its officers? Well, they certainly can. And we are living proof that the government continued to exist, because there's almost no fidelity in any of the officers of the government. But that's a side note, a mistake by Archibald here. He said, ought not the officers of every government to give some security for the faithful discharge of their trust? Well, certainly. But how do you hold them account? He said the officers are only to be sworn to support the Constitution, and therefore will only be bound by their oath so far as it shall be strictly pursued. And he continued, this is July of 1788, no officer will be bound by his oath to support any act that would violate the principles of the Constitution. And that brings me to what I think is the essential question. What does that mean in practice, whether it was at the time or today or sometime in the future? What does it mean to keep and honor one's oath to the principles of the Constitution, to the text of the Constitution, to the duties of one's office? Well, St. George Tucker, in his View of the Constitution of the United States, this was published in 1803. He was also a leading legal mind of the time. I believe this was one of the most cited works on the original legal meaning of the Constitution in law in the early part of the Republic, but someone else could probably tell me for sure the citations at the Supreme Court and things like that. But it was very popular, very widely read, and very widely understood. Here's how Tucker described it. Acts of Congress to be binding. And this is interesting how he was, and maybe I was thinking of this before as I was putting my notes together yesterday. It really is similar to the discussion over the Supremacy Clause as well. And he's tying it all together here. Acts of Congress to be binding must be made pursuant to the Constitution. Otherwise, they are not laws, but a mere nullity, or what is worse, acts of usurpation. Usurpation to the founding generation is stealing. It is theft of power. Because the people are the people of the several states under the Constitution are the fountain of all power, and government is only supposed to be acting as their agent. Government is only authorized to exercise those powers that are delegated to them in the Constitution, nothing more. End of story. And so anytime they go beyond those limits, they are stealing power. Anyways, Tucker continued with this. The people are not only not bound by these acts of usurpation, but the several departments and officers of the governments, both federal and state, are bound by oath to oppose them. For being bound by oath to support the Constitution, they must violate that oath whenever they give their sanction by obedience or otherwise to any unconstitutional act of any department of the government. So if we're really thinking about the oath of office, every single thing that the federal government does, that any government does that goes beyond the limits of the Constitution, if you swear an oath to protect and defend it, even just by mere obedience to it, you have violated that oath. And under that standard, I would say pretty much everyone is violating their oath today. Everyone has been violating their oath for a long, long time, at least in my lifetime, because it's impossible to be simultaneously part of the largest government in history, an organization that goes beyond the limits of the Constitution 24/7, 365. There isn't a moment that they are not violating the Constitution, or the state governments, which are mostly on their knees doing whatever the general or central government wants them to do. It's impossible to be part of that system and stay faithful to one's oath to the Constitution at the same time. And here's how Tucker put it, talking about legislators. if he concurs in an unconstitutional act, he is guilty of usurpation and contempt of the sovereign authority, which has forbidden him to pass the bounds prescribed by the Constitution. So anyone, I guess not just legislators, someone who signs something into law and says, oh, I really was pressured into this, it's a must pass, and there's a bunch of stuff that I don't agree with in here, but I'm going to sign it anyways because this is so important. That is violating one's oath. Everyone who passed it in the first place, they are violating their oath. Everyone who administers it in the deep state, enforces it, they are all violating their oath, and they're guilty of usurpation, contempt of the sovereign authority, which is the people of the several states. He said he has violated his oath, this is Tucker again, and the most sacred of all duties. But to omit him at the next election is not an adequate punishment for such a crime. Man, I had a really, really interesting quote here from Lysander Spooner on the oath of office that I thought would be interesting to pull up, but I guess I did not add it to my links here for the show. But I will link to it in the show notes. It's from his No Treason number 6, published in 1870. But ultimately, government-run schools, just like basically everything I cover on this show, they just don't teach this stuff. Because I think they want us to have a standard that government officials, they take these oaths of office, and then it's up to the government to determine if people in the government have violated the rules given to the government by the people of the several states. This is flipping the entire system upside down. Instead, it should be up to the people to hold them to a standard, to keep them in check, to refuse to support the people who steal power, who violate this trust, as Gouverneur Morris, James Wilson, and so many others have told us. And that's why we work so hard every single day here at the 10th Amendment Center to reach and teach more and more people about these essential founding principles from the founders and the old revolutionaries, how to enforce the Constitution and liberty when government refuses to do so, which is, again, 24/7, 365, and nothing helps us do this work more than the financial faith and support of our members. If you got a couple of bucks and that dirty government fiat from the unconstitutional Federal Reserve, please consider throwing it our way. We punch way above our weight class here at the TAC. 10thamendmentcenter.com/members is where you can join us. We also have annual, 5-year, and lifetime options. I'd be very grateful to any consideration you can give to joining us as a member today. And there's also a bunch of free and easy peasy ways you can help us spread the word, especially by triggering algorithms of the mainstream platforms, by hitting the like button, subscribing, getting notification, leaving reviews on podcast platforms, comments in the archives, etc., etc. Again, I really, really appreciate you spending some of your time with me today. I hope you enjoyed this episode. I hope it made you think. I hope you learned something. All that is way more important than anything. And I hope it was at least interesting to watch or listen to. And I hope to see you next time here on the path to liberty.